A testator used an easy form to draft a will, leading to a hard court battle involving her heirs in Aldrich versus Basile. Anne Aldrich purchased an easy legal form to make her will. On the form, she listed her home, financial accounts, life insurance, and vehicle. However, Anne didn't include a residuary clause, which would have directed the distribution of any unlisted property. Under Anne's will, once Anne died, her sister Mary would receive everything listed. If Mary died before Anne, Anne's brother, James Aldrich, would receive everything listed. Mary died and left Anne land and money. Anne opened a new account for the money. Then Anne drafted a document stating she wanted James to have all her worldly possessions. But the document didn't have enough witnesses to be a valid codicil. A codicil is a supplement to a will. Anne died, and a court decided the proper distribution of Anne's inheritance from Mary, or the after-required property. James claimed it, but two of Anne's nieces, Lori Basile and Leanne Krajewski, claimed a portion through intestacy laws. Intestacy laws outlined who inherited a decedent's property that wasn't disposed of with a will. Citing a Florida statute on testamentary intent, the trial court granted summary judgment for James. Lori appealed. The District Court of Appeal considered the statute. Under Sub 1, quote, "The intention of the testator as expressed in the will controls the legal effect of the testator's dispositions. The rules of construction expressed in this part shall apply unless a contrary intention is indicated by the will," unquote. And Sub 2 stated, quote, "Subject to the foregoing, a will is construed to pass all property which the testator owns at death, including property acquired after the execution of the will," unquote. The court reasoned that, though the trial court relied on Sub 2, Sub 1 applied. And because Anne specifically identified her property, omitting any after-acquired property, the after-acquired property would pass pursuant to intestacy laws. The court reversed and remanded, but sent a certified question to the Florida Supreme Court to ensure it correctly decided the distribution of the after-acquired property.